So welcome everybody. We are so excited to have you in class today. My name is Curry Sautner. I'm the Chief Learning Officer at the National Constitution Center. And I'm gonna be with you all in the chat today. If you have questions as the class goes on, feel free to put them in the chat for the Q&A and I will hold them and give them back to Jeff at the end of class. Today's class is going to be so much fun. It's 30 minutes, it's speed round, it's landmark Supreme Court cases, and we're gonna dive in pretty quickly. But I will start off with saying that it's really hard to pick just a few landmark cases to go over. So this is not all the landmark cases that you could dive into, just a few to get you excited so you can dive in and do more homework on your own. Now, without further ado, I'm so excited that Judge Krause is joining us today. She is a United States Court of Appeals judge from the Third Circuit Court, a huge and wonderful friend of the National Constitution Center, and has done such amazing work. So Judge, thank you for always teaching with us and joining our class today as well.
It's a pleasure.
Great to have you. I said we have done this so many times in the museum and now we get to do it online together. And then to lead us through this speed version is our CEO, President Jeff Rosen. So Jeff, without further ado, I will turn it over to you.
Thank you so much, Curry, and welcome, Judge. I'm so looking forward to our conversation. Let's jump right in. You decided not long ago a very important case involving free speech online. And our first case to talk about as a landmark case is Tinker, which was crucial to your case. But tell us what was going on in your case and what you held.
Yeah, absolutely. So this was a case that had come up from the Mahanoy school area school district, which is within the jurisdiction of my circuit. And the basic facts, probably most of our audience has heard about at least bits and pieces of this in the news reports as it made its way up to the Supreme Court. BL was a young woman who was at that high school, and she had not made the varsity cheerleading team in her freshman year, so sophomore year, when she only made JV and was frustrated about several other things. She and a friend on the weekend, outside of school, went to a Cocoa Hut convenience store, and they used a smartphone to post two photos to her Snapchat story, viewable by her friend group. And as I hope those younger members of our audience realize, you may think Snapchat disappears quickly, but if someone takes a snapshot of it and then sends it around, it has some lasting effect. Here, among the friends were other members of the cheerleading squad, and this eventually made its way back to the coaches in the school. So what was the problem with this Snapchat? Well, she and the friend raised their middle finger under a caption that you can use your imaginations, but basically said F school, F softball, F cheer, F everything. And then she sent another text saying, love how me and another student are told that we need a year of JV before we can make varsity, but that doesn't matter to someone else, without giving any names of any other students, and with an upside down emoji expressing sarcasm and silliness. But when the school got hold of this, they decided to suspend her from the cheerleading squad for the entire year. And she and her parents, as a result, brought a lawsuit challenging that suspension, that disciplinary action on First Amendment grounds. The district court had ruled in favor of the student. We affirmed, and to cut to the chase, the Supreme Court ultimately affirmed my decision. What's interesting is the different reasoning and the challenges in the way that the court went about applying some long established case law. And here, let me just very quickly hit on a few of the landmark cases in the First Amendment area around the rights of students in public schools. The seminal one, as Jeff mentioned, is called Tinker versus Des Moines Independent Community School District. And that dates back to the Vietnam War era, to 1969, when students were protesting by wearing black armbands into school and were suspended as a disciplinary measure because the school was concerned that with the different strong views about the Vietnam War, that this would lead to a disturbance within the school. There, the Supreme Court held in favor of the students' First Amendment rights to protest the war by wearing the black armband, and said famously that students don't shed their constitutional rights to freedom of speech or expression at the schoolhouse gate, even if it causes a disturbance. And the narrow exception and the test, the Tinker test that they announced there, was whether the speech in question would materially and substantially interfere with the operation of the school. So it had to be more than just discomfort or general worry. There had to be a specific and significant fear or disruption. And from there, about every 20 years, the Supreme Court has issued a major case on First Amendment rights of public school students. My case fits right in at that 20-year mark. 20 years after Tinker came a case called Bethel School District versus Frazier, which dealt with students delivering a speech at a school assembly using some pretty graphic and explicit language around a campaign for student council. And the Supreme Court upheld the right of the school to take disciplinary action there, explaining that teaching students not to use vulgar and lewd speech was important for the school's interest in teaching socially acceptable behaviors. So that was something that was recognized by the court as an interest and reason that you could justify censoring student speech. About 20 years later, also was Hazelwood versus Kohlmeyer, where students wrote an article in the student newspaper about teen pregnancy and divorce, and the high school decided that they didn't want that published on the grounds that it was inappropriate for younger students, took action. And the Supreme Court said there that educators could exercise editorial control because it was viewed as bearing the imprimatur of the school. People could look at that newspaper and think it was actually the school speaking. And in Morse v. Frederick in 2002, the Olympic torch was being passed through the streets of Juneau, Alaska, and this was during school hours. And a class, with the permission of the principal, went out as a sort of field trip to watch this. But while they were out, Frederick and some friends unfurled a banner that said "Bong hits for Jesus," which the school took disciplinary action about because they viewed it as advocating illegal drug use. And the explanation the court gave there, and saying that that was a reasonable action to take, was that there was also a government interest in stopping the drug use because of the health effects on students, or well-being of students as a rationale. So then comes our case a couple decades after that. And unlike in Tinker, we were dealing with speech that was off campus. It was on the weekend. It was not during school hours. The BL was not wearing anything that even indicated what school she was from. And it was a communication over a private server to her friends. So what test applied? We took a hard look at the question of whether a school could punish off-campus speech, which we defined as outside of school-owned, operated, or supervised channels, and that is not reasonably interpreted as bearing the imprimatur of the school. No one would mistake that for school speech. Indeed, she didn't even identify the school. This was an important case because the Supreme Court has not addressed until this point students' internet speech. And of course, as we've moved, especially in this COVID era, onto students communicating online for a variety of reasons, that takes on great importance. So we were considering whether the Tinker test was really the right test to apply. Does the schoolhouse gates extend beyond the physical gates and even beyond the school servers to sort of any time and any place now that we're in the internet age and students can carry around things like a cell phone? We looked at what some other courts of appeals had done and recognized that where there were cases involving threats of violence or bullying, which is where many of the cases in other courts had come up, that the courts, in saying, yes, you could take action against students there, had not been clear about what the test was. And in approving the school's disciplinary action, we're doing it in ways that could carry over to chill student speech in their private time and off of school grounds, even outside the context of class or anything involving the school. So we held that as a general matter, Tinker's authorization for schools to punish speech that could materially and substantially disrupt the educational environment, that test was really limited to what happened on campus, including in the virtual campus. That if there was a concern about what the consequences would be of someone speaking in their private time, outside of school grounds, outside of school hours, that was beyond the reach of the school. Although we acknowledge that in cases of bullying or threats of violence, that there might be other interests, and cited to some of those other cases where the Supreme Court in the past had recognized other interests that would justify censoring school speech, like the well-being of students around drug use, for example. The Supreme Court affirmed us 8-1, Justice Thomas dissenting. It did it on slightly different grounds. It recognized that students don't shed their First Amendment rights at the schoolhouse gates, but it expressed concern about drawing any line between where those gates were, began and ended in the digital age. And in an opinion by Justice Breyer that seemed to have a little bit of everything for everyone, the court identified just a number of different factors that courts should consider.
We may have lost her, Jeff.
Yeah. Judge, you've just frozen, and we hope you're going to come right back. But while we're waiting for you, I'm going to say that was such a superb breakdown of the cases leading up to your case, distinguishing Tinker and Hazelwood and all those other cases, and also answering Lois's question about the different grounds that the Supreme Court decided the case and that you did. And you were beginning to tell us about Justice Breyer's multi-factor test. I wonder if you can hear me, because you're still frozen. And if not, there we go. I bet the judge will be right back.
Right back, yeah.
That wasn't that.
Jeff, I have a couple follow, because I know you know this too. And that was literally my goal, was like, if the judge just broke down the First Amendment cases, that would be amazing. So that was amazing. But could you help with Beth's question real quick about what's the difference between a public school, a private school, or a private organization like the Boy Scouts? Because I think this really does help understand which schoolhouse gates are we talking about as well.
Crucially important question, Beth. The First Amendment, the judge is back, and I'm going to quickly, Judge, can you hear? Right, although you may be muted. Let's see. Oh, yes.
There we go.
Perfect. Wonderful. So glad you're back.
Yes.
Quick. I was saying what a wonderful breakdown of the cases that was, and it was just a tour de force. So grateful about that. Beth asked us what the difference is between public and private schools. And I was going to quickly say that the First Amendment says Congress shall make no law. It doesn't say that private institutions shall make no law. And therefore, private schools, unlike public schools, are not formally bound by the First Amendment. And you asked about the Boy Scouts, and the Supreme Court has held that the Boy Scouts do have the power to engage in discrimination against gays and lesbians, for example, that a public institution wouldn't because of its First Amendment rights as a private organization. Judge, I wanted to ask you, and I think we're going to end up spending much of our time on this crucially important First Amendment case, but it's a great use of time because your opinion is so important. I wanted, I have shared with you that I was persuaded by your firm distinction between speech that is off campus and speech that's on campus, and the concern that you expressed that unless that line were quickly drawn, then all sorts of speech within the home might be regulated in the internet age. And in preparation for our conversation, I was reading Milton's Areopagitica, this wonderful defense of free speech written that so inspired the founders. And there's a passage from there I wanted to read to you and then just ask you why you thought it was important to draw that line as you did. Milton says, if we think to regulate printing and have to get licenses before you can publish books, thereby to rectify manners, we must regulate all recreations and pastimes, all that's delightful to man. No music must be heard, no song be said or sung, but what is grave and Doric. There must be licensing dancers, that no gesture, motion, or deportment be taught our youth, but by what their allowance shall be thought honest, for such Plato was provided of. It will ask more than the work of 20 licensers to examine all the lutes, the violins, and the guitars in every house. They must not be suffered to prattle as they do, but must be licensed, is what they say. He's just going on and painting a very vivid example of how intrusive it would be on our private life and thoughts if the government were actually going to regulate or license or review everything we thought or said or sang or danced before we said it. And he concludes with a defense of the importance of truth that inspired Thomas Jefferson. He said, though the winds of doctrine were let loose to play upon the earth, so truth be in the field, we do injuriously by licensing and prohibiting to misdoubt her strength. Let her and falsehood grapple, whoever knew truth put to the worse in a free and open encounter. I just found all that so inspiring. Wondered what you thought, and then what reason you thought that it was important under the First Amendment to draw a firm line between speech in the schoolhouse and speech outside of campus.
Thank you, Jeff. That is putting it beautifully and poetically, and it is inspiring. The concern, putting that in some of our lay terms, is it's not only a problem that there might actually be censorship or actually any types of disciplinary action taken or a license that where you'd be penalized for not having it. It's the very fact that this could happen. And in the First Amendment realm, we talk about that as the chilling of speech, just psychologically, that students in particular, young people who may be very concerned about having some disciplinary action on their record will self-censor. And so those cases won't even come to the fore. And the reason to draw a firm line is that in the area of the First Amendment, that is at the heart of the innovation, the imagination, the core freedom of expression. There's a reason it's the First Amendment, and it's without knowing clearly where that line is and exactly what the criteria are on the side of students. We may see less speech. These are the very people, the young people, the next generation of Americans to whom we need to be teaching what the Constitution really means. And that needs to be through action, not just as an academic matter. The flip side of that, of course, is that administrators, unless the line is clear, also don't know what they can and they can't do. And that can lead to under or over regulation. So we had drawn this firm line. The Supreme Court, in their opinion, recognized a number of different interests, but
we've just lost you again. It's so dramatic because your words are so inspiring, and then you freeze in this great way. But we know you're going to be worth waiting to come back. There's no chilling effect to your speech because it warms us with the inspiration of the importance of protecting free and uninhibited debate. As the judge said, wait, now you're back. It's the court Wi-Fi, I bet, because they have to keep you secure, of course. So that's why you're. But please continue, because that was such a great answer.
So I was just saying that the Supreme Court ended up saying that these were the special characteristics of the school environment required the school to be able to regulate because they're stepping into the role of parents, in loco parentis during those hours. So the things that they said to consider when it comes to any speech, even off campus and even outside of those hours, include the extent to which the school was in that period taking over for the role of parents, the nature of the speech, if it was.
I'm going to jump in again as we wait for you. As you said, the Supreme Court was much more multi-factored. The nature of the speech, the conditions under which it was offered. Go ahead, and the contributions to democracy in general. You're back now.
Okay, good. What the court ended up saying made clear that off campus that schools should be much more hesitant about censoring speech or taking disciplinary action, but it didn't draw the firm line of saying that the schoolhouse gates, where a school can clearly regulate if they think that there's a likelihood of substantial and material disruption, are only those places, physical or virtual, where the school it belongs to the school servers, school sponsored activity, school grounds, a school event, for example. So, and again, just like when we looked at the other circuits and what the other circuits had been doing and trying to come up with a test, I think the Supreme Court was driven in large part out of concerns about the different kind of case that was not before us here, where there was bullying or threats of violence, which is a very real issue and real concern. And I think we all agree that when that comes to a school's attention, for the reasons that the court had articulated in Morris, that there's an ability to regulate there. But that's given the pattern that we've seen, I suspect it will be at least another decade and maybe two before we see another major decision like this from the Supreme Court on public student speech.
Well, that's an important and I'm sure true prediction. And it makes your opinion all the more important because it stands as a shining example of what drawing the line firmly looks like, which will be extremely important as these other cases are presented. That relates to a question from our friend Harper Zedek, who asks, how is the speech of college students treated differently than K-12 students?
So colleges, there are private colleges, of course, and there are also public ones. And most colleges are also accepting federal funds so that there can be some conditions that are attached to that. In those environments, because they're still students and but not in this younger group. So the First Amendment tests that are applied are not tinker per se. Once you get outside of that elementary, middle, and high school environment, but the First Amendment, when it comes to any public entity that's regulating or disciplining on the basis of speech, will still apply. And we've had various cases on college students exercising their First Amendment rights, where the interests at stake will sound familiar because, of course, that's still a place where we want to teach by example, by action, and not just intellectually. But the balance is different because it's not so much in loco parentis, where the college is stepping in for parents during those hours involving younger children. Those young adults are much more independent.
Wonderful. Well, we're going to have to close in just a moment. So I'll just ask what final thoughts you'd like to leave our friends with. We didn't discuss the other cases that are so important, from Marbury versus Madison to Dred Scott and Sanford to Plessy versus Ferguson and Brown. But perhaps sticking to the First Amendment, are there cases or books or readings that you found especially meaningful as you decided this crucially important case, or any other suggested readings or thoughts that you want to leave our friends with as they continue to learn about the First Amendment?
Well, let me say, Jeff, that I was eager to talk about many of these other cases as well, and I'm sorry that the time is so short. But I really encourage everyone to take a look at and read even summaries of these major decisions that came out of the U.S. Supreme Court dealing with the founding of the country, of the powers of Congress and of the judiciary in Marbury versus Madison and in McCulloch, Maryland, dealing with equality, with the evolution of the cases that, as Jeff mentioned, Dred Scott, Plessy, up to Brown v. Board, and important cases on the Bill of Rights, like West Virginia versus Burnett, Korematsu, of course, like Plessy and Dred Scott, an infamous decision that
the judge is just talking about Plessy, which wasn't. Oh, here now you're back.
And those civil rights cases, of course, bringing us all the way up to the First Amendment as civil rights case. In terms of particular reading materials, for the First Amendment, both cases, both opinions, I think, would be interesting places to start. There have been so many wonderful books written on the freedom of speech, freedom of expression, and related freedoms in the First Amendment: freedom of the press, freedom of religion, all sorts of ways that our Constitution protects the right to express yourself spiritually and otherwise. Jeff, if there are particular ones that you might want to recommend, I would certainly encourage you to add those as well. But yes, I know time is limited, so.
Wonderful suggestions. And as you say, the best place to start, friends, is by reading the decisions. What a privilege it is to learn from Judge Krause. And now you can read her path-breaking decision, which I think we're posting in the chat, as well as the Supreme Court's decision, and then just follow the footnotes and follow your curiosity and continue to learn and grow, which is your First Amendment right, just for the reasons that the judge said. Judge, it's been a privilege to learn from you and with you. I know we're going to try to persuade you to come back so we can return to the other crucially important cases that you mentioned, and I'll leave it to Curry to sign us off.
Thank you so much, Judge Krause. And remember, students, all of February is devoted to the First Amendment. So every single week, we'll be talking about a different clause in the First Amendment. But Judge Krause, I just also wanted to point out, I love the way you teach. You teach us not just about the cases, but how to break down the cases and how you break them down as a judge to analyze what are the parts that matter, what are the parts that we need to understand, and how are we analyzing it with these constitutional questions. So thank you for modeling that behavior for us today and teaching us not just the what of the case, but the how of being a judge. So thank you so much. We are going to make you come back over and over again. And with that, I hope you all have a wonderful day. Thank you, students. Absolutely great class, everyone.
Take care.
Bye.
Bye.
Thank you. Bye.